Your Honor, Assistant Public Defender Jay Bellinger on behalf of Mr. Ginyard.
For the record, Your Honor, my name is Terrence Ginyard.
And Your Honor,
He's waiving.
he is waiving. I do have an offer to place on the record. As it stands, that offer is that he waived for the purposes of pleading to one count of the firearms possession by a prohibited person. Count 2 and count 3 would be dismissed. It would also be a plea to count 4, the misdemeanor receiving and concealing 200 or more. That would come with the forfeiture of the weapon, restitution, if any, standard conditions upon that waiver.
That's people's understanding.
All right. Mr. Ginyard, you're waiving your right to a preliminary examination, sir? Yes, sir, Your Honor. All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. Yes, sir, Your Honor. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution. Yes, I do, Your Honor. All right. People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 through 3 with 4 following.
Your Honor, we would acknowledge receipt of information, waive formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute to all counts, court will enter a not guilty plea. Pretrial will be set for
January 27th at 1:30 before judge comes.
January 27, 2025, 1:30 before judge comes.
Your Honor,
Yes,
if we may address bond at this time.
briefly.
Your Honor, my clients, I think the court has the information from last time with regard to the blood results that he was able to take. At this time, I am still asking for his release. He's willing to do tether at whatever conditions that the court deems necessary. He received a 7-day notice to quit, eviction notice that starts today. He has also got a kid who is autistic, whose birthday is today. He lost his job, unfortunately, as a result of this case, understandably so. He's going to need to move out of that location, as the court knows, for purposes of securing new housing for his family, his children especially. I would just ask for a plea for his release at this time on PR.
Any response from the people?
No, Your Honor.
Well, why are you drinking? Sir? Go ahead.
So I got the blood test on the 2nd to show that I wasn't drinking. I wasn't drinking, Your Honor, on the 22nd. I didn't have any alcohol. That's why I went on my way to pay for a blood test. And the blood test, the levels was 1.0 and it said 1.4 is 0 to low alcohol.
Yeah, but
Yes, sir.
I remember going through all of that last time, and I'm telling you that test doesn't tell me much.
We understand that, Your Honor.
Because I got repeated tests where on the 22nd and the 27th, you're testing positive, you're drinking.
The one time I did say that I was drinking in November, Your Honor, I did admit to that. I definitely did. And you said we'll put it for
Put it over.
We'll adjourn it or whatever. And then we just got to this adjournment with what I proved that I wasn't drinking. And
you didn't, sir.
Oh, hold on.
Okay.
You didn't. That's not what that test shows me.
I have, so CMH has given me what I wanted to tell you, a shot.
The Vivitrol?
Yes, and that's like an alcohol blocker. And they said if I drink on that, bad things can happen to me.
Where is that information?
That's with CMH, sir.
Your Honor, I don't have receipt.
I don't have that before me. You're telling me that's
what I'm going to be put on. I'm already taking.
So you're not put on it right now?
No, sir.
Okay. Your Honor, I would ask for consideration for random drops at this point, if the court would be willing to consider that. I think that would, I think testing in front of someone at this point may be helpful in terms of monitoring the situation versus the scram tether or sober link. I would ask for consideration for that. I do know that my client has a desperate need to leave the jail.
I understand that, but I also understand what he's done to get himself there, because he wasn't there to start with. And now you're asking me to change it, and I haven't been shown anything. really that's convinced this court that those episodes didn't occur. And he's not on a medication that's going to stop him from drinking.
For your mama.
Hey, dude, I'm on.
Seriously. So this is, I mean, nothing's changed from the last time that I denied it. And so he'll be up before Judge Conkey. Maybe she'll feel differently than that, but
I'll do anything to any type of drops though, Your Honor. They do want to put me on the thing today as far as the Vivitrol. They told me tonight I can get a shot, but it's also if I'm going to be
You're
here.
telling me that, but I don't have anything that indicates that. I have nothing in writing saying that's what's going to happen.
I just was trying to move, man. I know I have to move, but I have a 7-day eviction. Since I've been in here, I don't really know what to do. I have an autistic son. I have a lot at home.
Ginyard, I understand and I can appreciate the circumstances.
No scram tether or anything I can do, sir, for you? Anything, just for a week, just to show till I come back to court.
I'm not changing my position on it. I've said what I've said. You can take it before Judge Conkey. She may feel differently. All right. Bond is denied. Thank you. Your name, ma'am?
Oh, Shalisa Floyd.
Thank you.
Your Honor, requesting to adjourn this matter. We're still waiting for some discovery.
How soon do you have it? I mean, if we're waiting discovery.
So I believe it's supposed to, we requested it the other day and I was supposed to be receiving a link, a WatchGuard link for the discovery, but I never received that link. So
We can give it to them as early as next week.
so 2 weeks.
Can we,
What did you want to say? You wanted to say something?
yes, sir. I was just,
I'll talk to you. I like talking to you more than I like talking to them. So go ahead. What do you want to tell me, ma'am?
I was just gonna say 2 weeks because I'm starting a new job at Chrysler, so I don't know what my, schedule
Your
is. gonna-
schedule's going to be?
Yes, sir.
All right. So when do you start that?
Next Thursday.
So you start that on the 22nd?
Yes.
All right. And then you're gonna have to get to your attorney. Everybody's gonna have to look at it. While we're doing all that, you don't want to lose your job.
No, sir, I don't. Thank you.
And here's what I'm gonna do. I'll put the probable cause conference out to February 12th, 2026, 9 a.m. And she's working and doing that. If she can find a way to get it done, then she submit the forms, let her appear via Zoom. And we'll try to time it up so she won't lose her job. You're welcome.
Thank you.
See, if they had said it, it would have all turned in and I would have just denied everything. But the way you asked. All right.
Address bond, sir.
Pardon?
Can we address bond also, sir?
Your bond?
Yes, sir.
Oh, you're
If
telling
she
her what to say now?
If she has, you won't deny it.
All right. What about her bond?
My bond condition.
Your Honor, she has right now, there's a no go to her current house where she lives, so she's not able to go there. So we are asking if we could change that to allow her to go back home. Right now, she's been living at friends' homes and she's still paying rent and mortgage on that home that she can't go to.
Your Honor, the people that oppose the modification to the bond, no go to, especially as the complaining witness is currently residing at that location. He is in the process of moving out. He's asked us to get at least 2 weeks for him to be able to do so. But at this time, he would like the no go to.
Your Honor, it's her home and he has no right to be staying in that home at this time
So how do you get in there?
because the no go.
No.
Originally he was staying with her as but
Yeah,
not as a resident there. It was just a one-time thing.
We were dating.
what?
We were dating. I'm in love with him. I am in love with him.
Okay, that's fine. I get that. And I guess that was gonna be my point. I understand it may be her home. But I don't really think, if this court's gonna be consistent, I'm not going to change that where that person is still in the premises.
So in 2 weeks, he indicated that he's moving out within 1 to 2 weeks. Should we,
Well, here's the problem. Even if she doesn't, or he doesn't move, then she's just caught at that point. I'm not going to change it to allow him to go, or allow her to go back until he's just vacated the premises.
Your Honor, when we receive confirmation that he has left the premises, I'll reach out to defense counsel. We can submit a stip to allow her to return to the address.
Well, I've given him an eviction notice already.
Okay, that's gonna be a whole other problem. Because whenever people are in the middle of a domestic,
I didn't give,
where's the property?
it is A359 Brookstone, Willis, Michigan.
I don't know if that comes here or not. It's in Washtenaw County.
yes. Yes, sir.
Right next to
Is
Ypsilanti.
that 14B? Is it 18? Well, there's only, well, if it comes before me, I'm gonna throw it out because I don't allow eviction cases on domestic cases either, for very good reason. So he needs to just move and then there'll be the stipulation and you can go back.
Thank you, Your Honor.
Okay, bound will continue.
Thank you.